For judgment from the supplementary clause list, item number 13.
The judgment is modified and enhanced to 40 lakhs 50,000. The others are signed later, okay? 100 pages. Yes.
Please, Leadership. Leadership, I'd like to mention item number 5. Leadership, here I'm appearing for respondents 1, 3, and 4. We will be filing our objection to the stay. The condonation has been condoned.
1,
1, 3, and 4.
3, and 4.
Yes, kindly allow me 3 weeks time. File my objection to the stay. Item 5.
In the main appeal?
Yes,
or in the IA?
the IA first stay.
Okay. Learned Counsel Mr. Nongosa appearing for respondent number 1, 3, and 4. Praise for
3 weeks time.
3 weeks time to file an objection in IA Civil 229 of 2025. Stop. Learned Counsel for the appellant Ms. Kim Penyu is present. Stop. List after 3 weeks as paid for. Yes.
Leadership, I also beg to mention item 11. Here I'm appearing for respondent number 1. We filed our objection if the matter can come up after 3 weeks.
10 and 11.
Yes, Your Lordship.
Yes. It should be 10 and 11. So in 10 you want to file objection?
No, we have filed our objection. Filed to the condemnation.
Okay, Learned Counsel for the respondent number 1, Mr. Nongosa, praise for how much?
Respondent 3 weeks time.
3 weeks time for hearing.
Yes, sir.
For hearing on the IA Civil 333 of 2026. So, Learned Counsel for the appellant Ms. Kim Penyu is present and has no objection. Please after 3 weeks. Yes.
May it please Your Lordship, Lordship, if I may be item number 5, Your Lordship. It's a concession prayer. Item number 6, Your Lordship. If the matter may be listed on 27/8/2026, Your Lordship.
27/8.
Yes, Your Lordship.
Okay. Learned Counsel for the appellant Ms. Kim Penyu prays for listing the matter on 27/8 with the consent of the Learned Counsel for the respondents. Accordingly, list on 27/8. Yes.
Lordship, I also beg to mention item number 9, Your Lordship. The service upon the respondent are still awaited, Your Lordship, in this matter.
All the respondents?
Yes, Your Lordship.
Item 9, Learned Counsel for the appellant, Ms. Kim Penyu, submits that service on the respondents is still awaited. Accordingly, list after 3 weeks awaiting service report on the respondents. Yes.
Bless Your Lordship.
My lord, I need to mention item 22. Here in this case, I am due to file the counter, and certain correspondence is going on between the authority and from my counterpart. So kindly grant 4 weeks time for filing my counter.
I have no objections.
Learned Counsel for the petitioner, Mr. Sentiang, is present. Mr. Pandang Wabang, the special PP for CBI, submits that certain correspondence is going on regarding what?
In connection with the present case.
Is going on with the respondents in connection with the instant case, and accordingly he requires some more time to receive the instructions. So list after
4 weeks.
4 weeks.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next date of listing. Yes.
Much obliged.
Lordship, in items 18, 19, 20, and 21. These are all ET matters represented by my learned friend, YP Gupta. It appears he is also online.
Okay, yes.
Yes, Lordship. I'm appearing for the respondent, Your Lordship. We have filed the affidavit.
In view of the part heard matter in items 15, 16, and 17 today, if my petition succeeds, the
Yes,
case-
yes,
yes.
automatically
yes,
this
my
will
lord,
also
yes, my lord.
be
Which is why
discussed.
if it can be deferred to, if it can kindly be listed after 4 weeks.
4 weeks, Mr. Gupta.
Yes, Your Lordship. No issue, Your Lordship.
Not counsel. This is 18 to 22. Okay.
21.
21. Yes. Learned counsel, Mr. Sentianger, prays for listing the matter after 4 weeks, as the said petitions are dependent on the outcome of the Civil Revision 10 2026, Criminal Revision 10 2026,
10, 11, and
10, 11, and 12 of 2026.
My lord.
Stop. And prays for listing the matter after 4 weeks.
4 weeks, my lord. Lordship, there is an interim.
Counsel for the ED, Mr. YP Gupta, is present and has no objections. List after 4 weeks. So the interim order passed earlier shall continue till the next date of listing. Yes.
Deeply obliged.
Deeply obliged, Your Lordship.
May I please, Your Lordship, may I please to mention item number 24. 24 on behalf of E.T. Bapong, Your Lordship.
My lord,
On behalf of 1 minute.
E.T. Bapong, Your Lordship, due to medical emergencies here, he has gone out of station.
This is that
Yesterday
matter which was
to be tagged up with item number 12 today.
Yes.
So he is actually requesting to list next week. Because of medical emergencies, he went outside.
Your Lordship,
And what about, is state the only party or private respondent?
no,
is
state
also-
is the party.
State is the party.
Your Lordship, I will make it in a different way.
No, where is the WP? WP is also listed
This is
today.
item number 12. That is with the service matter.
Achha.
So what I am requesting, let this matter come up. Accordingly, my lord may pass the order. Item number 12.
Item 12, who's appearing in item 12? Respondents?
Item number 12, Your Lordship, the appearance will be made from the Nagaland University. Item number 12. Because it is a.
Okay. Yes, so is anyone representing the Nagaland University in item 12? There also, nobody is there.
No, my lord,
For
let
the
it come up. Let it come up. Because there is an order, speaking order was been passed in item 12.
Okay, anyway, item 24, since PP is not there on medical grounds,
Then, my lord, the order to continue. There was a direction was been passed by the.
yes, learned
is the last
PP,
one?
Miss Livika, makes a mention on behalf of Mr. Tiba Pom, learned PP, who is absent today due to some medical emergency, and prays for listing the matter
Next week. Your
next week.
Lordship.
So, learned counsel Mr. S. Borgohang is present for the petitioner, who prays that the matter may be listed.
My lord, next week, let it be.
29, my lord.
29 is a Wednesday.
And my lord, let it come after 15th of August. Because the direction of 15/6/2026 to continue.
Wait. So 17th,
17th.
18th,
No, let it be on Friday, any Friday. 21.
21.
Yes.
On 21/8. Stop. The interim order passed on,
No, direction passed
or
on.
the direction passed on.
15/6
What is the difference?
The direction was there that the trial court is not supposed to dispose of the matter.
So that is an interim direction. Yes.
Your Lordship, I will quote it now.
The interim order passed on
15/6/2026.
2026 shall continue till the next date of listing. Yes.
Much obliged.
Obliged.
Right, please, Your Lordship. I'm praying for listing of WPC for today, if Lordship permits, my lord. Some urgency is there regarding cancellation of contract, my lord.
You want listing?
Listing motion matter today, if Lordship permits.
Unlisted?
Unlisted, my lord.
What is the urgency?
The tender has been cancelled, my lord, and now they are taking steps to encase the bank guarantee, my lord.
Monday? We can take up on Monday.
My lord.
List on Monday, huh? Yes.
My pleasure, Your Lordship. Lordship, if I may be allowed to make a mention, item 4.
Item 4, yes.
Lordship, the affidavit reply is still under preparation, Lordship. So if I may be given 2 weeks' time.
Learned Counsel Mr. Mang Jong Pom for the petitioner submits that he is yet to file the reply, is it, to the affidavit in opposition of the respondents, and prays for 2 weeks' time to file the same. Stop. Prays allowed list after 2 weeks. Yes.
Then may be allowed to continue.
The interim order passed earlier shall continue till the next date of listing.
Lordship, I may be allowed to mention item number 2 on behalf of Mr. Zep Kohima for respondent 1, 2, and 3.
Item 2.
Item number 2. Your Lordship, I'm informed to pray for a week's time to file his objections.
On whose behalf? You are praying on whose behalf?
On behalf of Mr. Zep Kohima.
Zep Kulno, okay. And who's there for the petitioner?
I'm for the petitioner.
Okay, any objection?
No.
Learned Counsel for the petitioner, Mr. Fosiko Forte is present. Mr. Mangchong Kongyak submitting on behalf of Z Kulno, counsel for the respondent number
3.
Prays for listing the matter after
A week.
a week, as the council has some difficulties today. Praise the Lord. List after 1 week. Yes.
My lady, there's an interim. Can
The
they
interim
continue?
order passed earlier shall continue till the next date of listing.
I'll look first, lady.
Before typing out, you check whether the interim order is there, okay, in the main file. Yes.
For motion from the supplementary cost list, item number 14.
Please, my lord. Your Lordship, here, this alia arises from one writ petition WPC 114 of 2026, which was filed on 14/7/2026, Your Lordship, where one impugned resolution issued by the village council was challenged before this honorable court, where the disputed land,
Chedima Village Council.
yes, Lordship, has been declared as public property by the Chedima Village Council. So I've challenged that particular resolution, the writ petition. So on the listed, the interim was not being granted, Your Lordship.
Did you pray for the interim order?
Yes, my lord. And then, however, the High Court was pleased to consider the matter, but then no interim protection was granted. And then now, due to subsequent set hearing, there has been significant and material developments which necessitate urgent intervention of this honorable court.
Order dated 16/7.
My lord.
But there is no mention here that you had pressed for the interim.
Yes, my lord. I've praised your lordship, but then the High Court didn't mention anything, your lord, regarding that. So I have to come up with another IA due to subsequent development made by the village authorities.
For setting aside and questioning the impugned inquiry conclusions and
My lord, I'll take you straight to the annexure to page 18, my lord.
Let's see the impugn order.
Yes, my lord. Page 19, Annexure 3, translated copy is at page 20. I'll read from the second paragraph, my lord.
1 minute. Yes.
From the second paragraph, that is Village Resolution and Decision dated 5/7/2026 decided the land where the present government middle school Chitima stands in its surroundings was given by late Zipu, that is the forefather of the late Zipu descendants, to be a public property. On 3rd of July 2016, the villagers leaders hereby strongly uphold the same resolution. Based on the meeting resolution dated 11/8/2019 and 14/1/2024, duty on the 5th of July 2026, the village leaders in its meetings decided that late Zipu Jagrono descendants should obey or follow the resolution of 11/8/2019 and 14/1/2024 before 15/7/2026. In the event of disobedience, the following action will be taken against the descendants of late Zipu Jagrono with effect from 16/7/2026. And these are the conditions. They will lose all the rights and benefits given by the government in the village. 2. No documents will be issued by the village authority to the descendants of late Zipu. Number 3. Late Zipu descendants will be barred from holding any leadership post in the village. Number 4. Any person who takes the side of the late Zipu descendants shall also be punished with the same consequence. Number 5. For any necessary steps to be taken, the village leaders will be decide for the welfare of the people. This was the condition. And then, Your Lordship, the parties, they are aware that declared suit is pending before the civil court, which I've also mentioned in the earlier petition also, and even in the IA. But then, Your Lordship, instead of considering the case which to be determined by the trial court, now the respondent number 3, the village council, they are passing this impugned resolution, and due to this impugned resolution, now the deadline was given till only 15th.
This resolution was taken after the declaratory suit was filed.
Yes. It was passed on 5th of July. 5th of July 2026. And then I was given direction to abide by the resolution before 15th of 2026, this month. Now it page 29. Annexure 6, my lord.
Page 29. Yes.
Now they have published in the local list, that is the Chapi Pep newspaper. I've made the translate copy at page 31. This is important to me, Your Lordship. Office of the Chitima Village Council, dated 17/7/2026. Chitima Village Resolution Decision. Chitima Village had collectively owned a plot of land where GMA's local ground and Panjat Hall are located. Each clans have given its share, and the state lands are considered as public property, community property, and not as individual land. However, the descendants of late Zipu Chakrono claiming that land ownership of the GMS Chitima is before the court for many years against the village. The High Court had dismissed the case, but still they had filed a case before the High Court and Civil Court, and for which further developmental activities has been stopped. Therefore, the leaders of the village council and frontal organization held a meeting and decided that late Zipu Chakrono descendants shall be punished as per the rules practiced by the then forefathers with effect from 16/7/2026. And these conditions are the conditions laid down in the resolution. But then here, my lord.
Actually, have you annexed the suit, plaint?
I've annexed the order passed by the annexure to page 18.
This was filed by the attorney.
Order dated passed on 1st of June 2026.
Okay.
So unless this honorable court pass in them, your lordship,
Here, General Counsel for the petitioner / applicant, Mr. S. Wali. Stop. The instant application has been filed praying for interim stay of the impugned decision dated 5/7/2026 passed by the office of the Chedima Village Council, Kohima, Nagaland, by which, where is that 5/7? Impugned order, page.
Page 20. Annexure 3, page 19.
By which it was decided that the that late Zibo Chakruno, ZEBU-O Chakruno, CHAKRUNO, Chakruno's descendants should obey/follow the resolution of 11/8/2019 and 14/1/2024 before 15/7/2026. Stop. And in the event of disobedience, the following actions will be taken against the descendants of late Zibo Chakruno with effect from 16/7/2026. And then there are 5 points, page 20 of the IA. You just write down these 5 points, okay? Stop. Stop. Learned Counsel submits that the applicants herein had filed a writ petition being WPC 114 of 2016 on 14/7/2026, which is pending disposal before this court, wherein they had prayed for a direction to quash and set aside the impugned resolution dated 5/7/2026. Stop. The WPC 297, sorry, wait. It was also stated by the applicants herein in the writ petition, in WPC 114 of 2016 that the
My lord,
applicants /
2026, my lord.
Oh, sorry, yes, 2026. No, but in your petition, you just see you have
Lordship,
written
yes.
2016.
My lord.
You correct that.
Yes, my lord.
It should be 2026. Okay. That in WPC 114 of 2026, the writ petitioners had also stated that the petitioners / applicants, along with 4 others, had filed a declaratory suit number 1/2026 before the civil judge, Senior Division, Kohima, for determining the land ownership of the present government middle school, Chedema, and the same is also pending disposal before the trial court. Stop. However, the respondents, notwithstanding the pendency of the trial suit, had issued the impugned resolution dated 5/7/2026. Stop. Para. The learned counsel for the petitioner applicant also submits that on 16/7/2026, this court had issued notice in the writ petition 114 of 2026. However, no interim protection was granted at the motion stage. Stop. Subsequent to 16/7/2026, there have been significant and material developments which has necessitated the filing of this application. So, learned counsel for the applicant has drawn the attention of this court to the newspaper publication on 17/7. Which
18
paper?
18th of July.
On 18th July 2026 in the Chapi local daily, where the resolution dated 17, isn't it? That resolution they have reproduced in the paper. Is
Yes,
it?
resolution
Or-
dated 5/7/2026.
Or is this a new resolution?
Same resolution, the criteria, only the criteria are same, criteria.
Wherein the same resolution which was adopted by the impugned resolution dated 5
7.
5/7/2026, isn't it?
Yes, ma'am.
No, not 5/7/26.
5/7/2026. Page 19.
Oh, yes, 5/7/2026 was published. Was published, huh? Stop. Hence, the present application has been filed, praying for a direction to restrain the respondent number 3 from acting upon the said newspaper resolution dated 18/7/2026 and the resolution of the village council dated 5/7/2026, and also prays for staying the operation and implementation of the impugned resolution dated 5/7/2026 passed by the respondent number 3. Stop. Paragraph. This court has considered the submission of the learned counsel for the petitioner and also perused the pleadings. So, at this stage, it is directed that the impugned resolution dated 5/7/2026 as well as the impugned newspaper publication dated 18/7/2026 shall remain suspended till the next returnable date. List
Your Lordship, my presence for respondent number 1 and 2 may be reflected. Status official respondents.
Ms. Livika, learned government advocate, has entered appearance for
One and
respondent number 1 and 2, and the learned counsel for a petitioner shall take steps for service on the respondent number 3 by speed post as well as usual process within 3 working days. List along with the WPC 114 of 2026. Okay.
Obliged, Your Honor.
For admission from the supplementary cost is item number 15, 16 and 17.
I think we will take this up plus at the end. Okay. Call the other items.
For admission, item number 1.
Your Lordship, I am appearing on behalf of E.T. Bapam. He has an instruction to appear for respondent number 4. He has already entered his appearance. However, he is yet to receive instruction. Respondent number 4.
Respond for who?
E.T. Bapam is
Bapam.
appearing for a respondent number 4.
Okay.
Lordship, let this be the last chance.
This is regarding what? Regularization.
Regarding creation of non-supernumerary posts.
The other respondents have filed their affidavits.
Yes, Lordship. Lordship, I'm appearing for respondent number 2 on behalf of M1 Kumar, Lordship.
Learned counsel, Miss, I always forget your name. Ayala Imchin is present for the petitioner. So, learned counsel, Miss Kim Penyu is present for respondent number 2. So, Miss Levika submits that, learned counsel submits that Mr. Tipapom has received instructions to appear on
No,
behalf
he's yet to receive. He's entered. I think he has already entered his appearance for respondent number 4.
It is not recorded. Oh, yes. That Mr. Tipapom appears for the respondent number 4.
Yes.
However, he is yet to receive the instructions. 1 and 4. He is appearing for 1 and 4. But he is yet to receive the instructions.
Your Lordship, I instructed that he's only for number 4. So unless there is an authorization, I think that.
Because in the other orders, it says 1 and 4.
Okay, if that is the case, Your Lordship.
Okay, 4. Respondent number 4. What happened is that on 25/6/26 he was instructed to get instructions as to whether it is the home department or medical department which will create the post.
Your Lordship, I will-
Yes.
Since I think because of the medical emergencies, we.
That order is there.
Okay, Your Lordship, I will convey to
It
him.
appears on behalf of Mr. Tibapom, who is appearing for the respondent number 4. Stop. And prays for some more time to receive instructions. Stop. On 25/6/2026, this court had directed Mr. Tibapom to obtain specific instructions from the government as to whether it is the Home Department or the Department of Health and Family Welfare who shall create the supernumerary post as directed by this court. Stop. List on.
Your Lordship, after 3 weeks.
Not 3 weeks. Let it be 2 weeks.
Okay, Your Lordship,
List
for
after 2
instruction.
weeks in order to enable Mr. Tibapom to receive the necessary instructions.
For admission, item number 3.
Please, Your Lordship.
Yes.
Lordship, we have taken steps upon respondent 1 through the mode of dusting. And we have also filed a compliance affidavit on 25/6/2026.
Respondent 1.
Lordship, yes.
Anyone appears for respondent 1?
They've not had their appearance.
Respondent 1. Who is respondent 1?
PNAR.
The PNR.
Learned counsel for the petitioner, Miss Grace Namgi is present. Stop. Learned counsel submits that the service is completed against the respondent number 1 as the steps have been taken by Dusty and the affidavit of compliance has also been filed on, when did you file?
25/6/2026.
25/6/2026. Stop. Annexure A of the said affidavit of compliance shows that the steno attached to the Secretary PNAR has already received the copy of the petition. So accordingly, the notice on respondent number 1 / Muhammad, is it Muhammad Ali Shihab?
Yes.
IS is deemed served. So today when the matter is called, none appears for the respondent number 1. So Miss Viveka submits.
Your Lordship, on behalf of IAME, Your Lordship, she is for 2 and 3, Your Lordship.
And what is her prayer?
Your Lordship, I think the PNR will give an.
They have already filed their affidavit.
Okay. PNR is the main party.
Lordship, yes.
Ms. Livika submits that Ms. AIME is appearing for respondent
2 and
number 2 and 3. So, as the respondent number 1 is the principal respondent in the present petition, await the appearance of respondent number 1 and list after 3 weeks.
Okay. Much obliged, Lordship.
That's all. Yeah, we call, because hearing will take time, no? So we will do that. We call the orders.
For orders, item number 7.
May I please, Your Lordship? Yes. Service upon respondent 2 and 3 is still awaited. So, Your Honor, if I may be allowed to go for substitute service through paper publication.
Yes, learned counsel for the appellant is present. Stop. The office note dated 14/7/26 indicates that respondent number 3, that notice on respondent number 3 has returned unserved with the remarks no such person in the address. Stop. The notice on respondent number 2 is also yet to be complete. 2 and 3, isn't it?
Yes, ma'am.
It's yet to be complete. Stop. Learned counsel for the appellant therefore prays that she may be allowed to take steps on respondent number 2 and 3 by a substituted summon through publication in the newspaper. So the prayer is allowed. Learned counsel shall. 2 and 3 are residents of Nagaland.
happens in Manipur.
Then in that case, you have to publish in Manipur daily.
So,
That is allowed. The appellant shall take steps for publication of the notice in local dailies of Nagaland and Manipur and file the compliance affidavit by within 4 weeks. Okay. This after 4 weeks.
For orders, item number 8.
May I please, Your Lordship?
Yes.
I seek your permission to allow me to appear to via receipt.
Your audio is not clear. We cannot hear. We cannot understand what you're trying to say. Child court record is here. Yes. What are you saying?
Lordship, I seek your permission to appear via VC.
Yes, yes.
Okay. I'm appearing for petitioner, Lordship.
Okay.
Lordship, as per the last order, trial court record was called for.
Yes, that has been received.
Yes, Lordship. But as the settlement withdrawal affidavit has been filed by the complainant, I and Apex Court, I have mentioned in my petition, page 5, paragraph A. Lordship, may kindly come to page 5 of my petition, para 8.
Yes.
Lordship has it, para 8.
Right, yes.
I have written it, I have detailed it in this in my petition. Held by the Apex Court.
Okay, this is regarding settlement outside the court.
So crushing of yes, Lord. Settlement affidavit
That's
has
why
been filed.
basing on the settlement.
Yes, Lordship.
But have you impleted the complainant?
Yes, Lordship. Complainant affidavit. I
Complainant
have served the dusty service.
Appeared yet.
The
I don't know
complainant
whether
hasn't appeared. And what about notice?
May this Lordship? Lordship, I for the respondent complainant.
Okay. Yes.
As a compromise affidavit filed within the parties.
Do you have any objection?
No objection, Lordship.
Okay, then we'll dispose it. Okay.
yes, just if you're inclined to quash the FIR, Your Ladyship, the state machinery has been put into action and subsequently charge sheet has been filed. So, Your Ladyship, if Your Ladyship inclined to quash, then it may be disposed of with a cost, Ladyship, and to be deposited towards the welfare fund of the Bar Association. So that's my submission.
High Court Bar Association.
Yes, yes, yes. The offense itself is serious, in fact.
Yes, but even if the trial continues,
That is-
since they
that-
have already compromised, nothing will happen.
Ladyship. But since the state machinery has been put into action.
Okay.
Yes, Your Ladyship.
How much do you suggest?
It's up to Your Lordship.
10,000.
Very well.
Okay. We will impose some cost, okay? Because it's been going on for a long time. See, this
Yes, and the
it
charge
was
sheet has been
registered
filed.
on. It was
Registered 20.
registered on. FIR was registered on 18/3.
18.3. Yes, 18.3.
2026.
But then before filing of the this writ petition, the charge sheet has been filed.
Charge sheet was
Yes,
filed.
yes.
Pay for a minimum amount.
We'll see. Okay. The instant application under section 528 of the BNSS has been filed praying for quashing of the FIR and criminal proceedings relating to GR number 143/2026 arising out of Dimapur East PS case number 56/2026 under section 109 clause 1, 115 clause 2 of the BNS on the ground that the victim and the complainant have already arrived at a compromise settlement during the pendency of the investigation. Stop. Heard learned counsel. Your name? Heard learned counsel for the petitioner, such and such. Stop. Also heard Miss S. Mary, learned PP for the state of Nagaland, as well as Miss. Who's appearing for the respondent? Such for the respondent number 2. Okay. The instant petition, the facts leading to the filing of the instant petition is that on 18 March 2026 at around 8:30 to 9 p.m. an altercation broke out between the complainant/respondent 2 and the petitioner, escalating to a physical assault, while when the complainant/respondent number 2 was at his friend's place for dinner. After the dinner, while the complainant was leaving, a scuffle broke out between the petitioner and the complainant, purely out of a misunderstanding. Stop. Thereafter, the complainant/respondent 2 lodged an FIR before the Dimapur East Police Station, and in this connection, a case was registered as Dimapur East PS case number 56/2026, corresponding to GR number 146 of 2026 under section such and such, as mentioned above. Stop. Stop. During the investigation, the complainant respondent number 2 voluntarily approached the petitioner's parents to settle the issues, stating that the offences committed by the petitioner were unintentional and that the FIR dated 18/3/2026 was lodged due to a misunderstanding. Stop. The complainant/respondent number 2 also swore an affidavit stating that he no longer wishes to pursue the case against the petitioner, and write compromise/settlement affidavit dated 27 March 2026. The parties settled the matter amicably between themselves. Stop. It is also stated that charge sheet was already filed before. It is also stated the charge sheet has already been filed in the instant case, and the matter is now before the learned trial court. Stop. The learned counsel for the petitioner/accused relies on the case of Naushi Ali, Naushey Ali, and others versus State of UP, and another in SLP criminal number 3432 of 2023, wherein by order dated 11/2/2025, the Honorable Supreme Court had held that a non-compoundable offence can be quashed on the basis of compromise if the facts do not support the charge, thus holding that a mere mention of the offence in an FIR does not bar quashment. Stop. Hence, the learned counsel praised that the inherent power of under section 528 of this court may be invoked to quash the FIR registered before the Dimapur East PS case, and also the consequential criminal proceeding in GR case number 143 of 2026. Stop. Para. Learned counsel for the respondent 2 slash complainant has also appeared and submitted that the respondent has no objection, respondent 2 has no objections regarding the prayer made by the petitioner in the instant application. Stop. Para. Donut PP Miss Experry, while not disputing that the criminal proceedings can be quashed by this court in the present petition under section 528 of the BNSS, praise that costs may be imposed on the parties as the government, as the criminal machinery had been set in motion and the investigating agency had already invested time and efforts in investigating the case and filing the charge sheet. Stop. Para. This court has considered the submission of the learned counsel for the parties and has perused the records. Stop. No, peruse the pleadings. You say peruse the pleadings. Stop. The trial court records have also been received and the same has been perused in detail. Stop. Para. This court has also examined the settlement deed is page 11, annexure B. Where are they? Settlement deed. Has also perused the settlement affidavit dated. There is no date also.
27 March.
27 March 2026.
27 March.
27 March 2026. Stop. In the settlement affidavit, the respondent number 2 has sworn an affidavit that he is the complainant slash victim in GR case number 143 of 2026 and that he had lodged the FIR on 18/3/2026 against the petitioner slash accused. Stop. It is also stated in the said affidavit that he has no objections if the FIR and all the consequential proceedings are closed by the court against the accused persons. And it is further stated that the compromise declaration is in the best interest of all the parties in order to maintain peace and harmony, and that he does not wish to pursue the case further. Stop. This court has also observed that the said statement of the complainant slash respondent has been made without any fear, pressure or coercion. Stop. In view of the facts and circumstances as stated above, it is observed by this court that it would be a futile exercise to continue with the criminal proceedings in the instant case, as the same would not result in a conviction. Stop. Accordingly, the FIR dated 18/3.
18/3.
FIR dated 18/3, as well as the consequential proceedings in GR number 146 of 2026 is quashed and set aside. Stop. Para. subject to the condition, or you can say, is quashed and set aside, along with, subject to the condition that the parties, that the petitioner and the respondent number 2 shall deposit an amount of rupees 10,000 before the registry of this court, which shall be released to the High Court Bar Association. Yes. With the above directions, the instant application stands disposed.
Much obliged, Your Lordship.
Coordination, item number 12.
Your Lordship, I will take my lord to the order.
16.6.
Yes, Your Lordship. It will clarify the entire crux of the matter. The impugn order is of 2/6/2025. That is the order by which I was being showed the door. Now, kindly come to the para 2 of the order. The learned counsel submits that an inquiry was conducted by the memorandum dated 28 February 2025 under the provisions of Rule 14 of the CCS. He submits that the rules of 65, being a statutory rule framed by the central government under the proviso to under Article 309 of the Constitution of India, and not having been adopted by the Nagaland University, the very conduct of the inquiry under the said provision is void ab initio. Moreover, compulsory retirement not being a penalty, imposition of the same by way of statute number 28(2) of the Nagaland University is also illegal and should be set aside. The learned counsel therefore submits that in absence of any adoption of the rules of 65 by the university, the entire process of inquiry and the ultimate order issued against the petitioner should be interfered with by this court. Notices were issued. Your Lordship will find the respondent number 1, that's a formal party, Government of India. The second and 3 other relevant. Okay. Now, Your Lordship, what happened is that I will take my lords to those rules.
No, but steps taken.
Steps has been taken. I've been told my steps has been taken. I want to kindly peruse the office note.
Service of authorization. No, but service report is still awaited, of course.
Against respondent number?
Against respondent 2 and 3. Against 2 and 3, service report is awaited. See the office note dated 18/6/26. It was, steps were taken only on 18/6.
Yes, that is in compliance with the order.
18/6.
Within 3 days. 16/6, the order was passed.
Written service is awaited. We will direct the registry to obtain the tracking report since it was sent by
Otherwise, Your Lordship may permit us to give it in dusty.
Okay, dusty also.
Dusty will be much more better.
Because in the absence of the 2
and
and
3,
3,
my lord,
I don't
understand,
want to
I
pass
understand.
any orders.
And Your Lordship, I am sorry to bring your knowledge. There was a slight error in that earlier criminal order 24. I want to place it so that Your Lordship may correct it. Otherwise, it may create an issue before the learner. Please see this order. The deduction.
Or in the criminal petition.
Criminal matter, madam. Kindly come to my lord, third last
No,
para.
that you should have mentioned when we
I
were.
was mentioning, Your Lordship. I was mentioning, but Your Lordship told that interim is there. So I verified it. That was not interim. It was a direction that trial court cannot proceed. So the direction, instead of interim order, your lordship should insert the direction. Passed in
Let's see, page, last page.
last page. While no order of stay is made at the state halting the trial, nonetheless the learned trial court shall not dispose of the trial during the pendency of this criminal proceeding.
Okay.
So that has to be direction.
Acha, acha. Then in that case, that item
24.
item 24, instead of saying interim order, you just say that till the next returnable date, the learned trial court shall not dispose of the trial during the pendency of the present criminal proceeding. Okay, or you can say during the pendency of this criminal petition. So, yeah, that will do.
That will do.
And then
Because we
in
are going
this
to appear
case,
before, that's why, my lord.
then in this case, we will await service report, and then you take steps by Dusty.
Dusty. Then in that case, my lord, let it be fixed on the next day, on the same around date. It has been taken.
The other one was listed when?
Other one is this?
Criminal petition? 21.
Let it be then 20.
21/8, the other one.
So let it be a common 20, my lord. Thursday.
Okay. Learned counsel for the petitioner, Mr. S. Borgohain, is present. Stop. The office note dated 18/6/2026 indicates that the return service report is still awaited in respect of respondent number 2 and 3. Stop. Learned counsel for the petitioner prays that he may be allowed to take steps by Dusty on the respondent number 2 and 3. Stop. The prayer is allowed. Stop. The learned counsel shall take steps by Dusty and thereafter file the compliance affidavit. Stop. List on 28.
August.
28. Yes.
Oblige, your lord.
For admission from the supplementary cost is item number 15, 16 and 17.
I think we can conclude this today. No? It is only 11:30.
Yesterday, my lord, I was expressing in connection with the amount,
Yes.
contractual amount and the amount that they have received. So, shall I continue?
Please continue.
The accusation against the accused petitioners are narrated at page 87 to 105 of the criminal petitions.
Page
87
87 to
105.
yes, from 16.8.
Yes. So yesterday I was emphasizing on that since the report is there, just to save the honorable time. Let me not go through the entire contents. If situation permits, only I read it out. So out of the payment received by the accused petitioner at different point of time, amounting to 4,52,99,286, that has been clearly indicated by the petitioner at page number 4 of your criminal petition.
Oh, that they are also admitting.
They are admitting, CBI also
that
admitting
is
to that.
received.
But
There
here,
is no dispute.
yes. Why
The only question is whether that was excess or not.
Yes. So I'll come to that point. Based on the measurement book, the amount of misappropriation amounting to rupees 29,68,345, that is 25,98,568.75 was for the shortage of the mini highway, about 300 plus meters. Then, for the shortage of 200 in something checkered tiles with footpath, 3,78,777. So this club up together as 29,60,000. 345. So this particular amount was paid in excess by the government officials who are charge sheeted in the instant case, along with the accused petitioners. The accused as well as the engineers are bound to maintain the MB book jointly with signature from the contractor or its agents in order to maintain transparency. Yes. Now, against the contract value of 5 crore 81 lakh 85,000, the contractors in every contractual work they are liable to pay various kinds of taxes such as central sales tax, state sales tax, value added tax, TTS, seas, forest royalty, and many other unaccounted taxes which are open secrets to different agencies. If those taxes are accounted, minimum of minimum of 22.25% are to be borne by the contractors against the contract value, then the taxes, if work out, it exceeds the contract value with a high margin. That is one very crucial aspect that the court has to take note.
That one is from where? Where are you reading from?
I'm giving my submission.
Okay.
My submission.
Okay.
Yes.
It is beyond the records.
No, not beyond the record. We are confining to the amount that work value that my learned friend has annexed the work order and the amount that the petitioners they have received. I'm trying to come and do a comparison because all these are the issues that it involves here. So now here D admitted that 4 crores 52 lakhs was received. So if the taxes are being deducted, the amount that they are supposed to receive is only about 3.51 CR. If the taxes are to be paid, because without the taxes, how can the government survive? Otherwise, how can the all entire contractual work can go ahead? That is one aspect the court has to say. If that value, taxes has been deducted, then what they intend in the petition.
Is there any document anywhere showing the percentage of work completed?
No.
Because every now and then in any contract work they issue that percentage, so much percentage
It
completed.
will only be in the measurement book, which the engineers maintain. It is not with us.
Because according to the percentage of work, the running bills are given.
Yes. Yes. And as mentioned in para 16.28, 4 crore work was already executed for about 4 crore 81 lakh something. Out of that, we receive, after deduction of taxes, we receive 4.52 something.
And at any point of time during the investigation, were the MB books seized?
Yes.
Or it's with in the custody of the investigating agency?
And nowhere in the charge sheet filed by the CPR, there is allegation of the presence of the contractor's signature in the MB book. It is all.
But this is
It
very
is all the
obvious.
signature of the. It is all. The allegations are that there is signature of the government engineers. Yes.
Yes, we will go by the charge sheet only.
Yes. Yes. It is clearly reflected in the chart.
Then?
So, the point that I was submitting, my lord, in 3 running bills they have received no doubt. So, if the after the deduction of the taxes, suppose if they have received 3.51, no doubt, whatever amount that is now they are saying that there is their amount is still pending, then that is sufficed. But here, 4.52 gross has already been received against the work value of 5 crore 81 lakh 85,000. And if we work out the assessment on the part of the taxes like so, then it exceeds. And if 22.25% is to be accounted, then it is in the nearest range. So whatever amount that is supposed, that is left out in the exchequer, otherwise they are saying that they have payment to be received from the government, it only covers the taxes. That is what I'm trying to come out. Because there is a difference on the work value, payment received, and on the basis of the work that they have executed, they have already received. In the CBI is saying that out of 4.52 crores, 29 lakhs point something has been misused. That means misappropriated by making excess payment. That is the contention in this case.
But who has made the payment? It is the engineers who have
It
made
is
the
the
payment.
engineers now,
Yes.
but here,
And there's
check-
nothing to
check-
show in the charge sheet that the petitioners knew about the calculations or that they knew what
that's why,
percentage. Then
unless
there's
and
nothing.
until the measurement books has been checked through at the time of the trial, if considered,
No, but even in the charge sheet, it was incumbent on the part of the investigating agency to state all those, that in the MB book it was like this, that it was
Yes.
only so much percentage was complete, but this much was given. That is not there.
to that extent, I'll come. I've certain points to argue on that also.
Okay.
Okay. Now, during the pendency of this criminal petition under 482, that is the other
And moreover, another aspect, how 120B will come in now?
here,
When the engineers are not there anymore.
they are not there anymore, but no doubt, under the Act,
Because contractors amongst themselves, there is no 120B. They are only alleging between contractors and the engineers.
They are one and the same person in law. Yes.
now,
I've mentioned that in my.
if that is the case, then they can come at the trial stage that 120B does not exist against them. Otherwise, under Section 216, they have a liberty to take the.
No, but charge is already framed under 120B
Yes,
also,
that's
isn't
why.
it?
So at the time of the argument of the trial, they can apprise the trial court so as to
Charge already framed.
judge already framed. That I understand.
120B
But
also.
see, in every criminal case, though charge has been framed and the allegation cannot be brought out against that, then the trial court has to take into consideration those things.
No, but at the time of charge, normally we either drop or add.
Yes.
So at the time of framing, they have already framed the charge.
Yes.
120B also. Anyway, yes.
I'll come to that extent also. It's up to this honorable court whether to consider my.
No, these are just questions which are arising.
Yes.
So just to clarify.
So during the pendency of the criminal petition under 482 before this honorable court, one, on the insistence of the accused petitioner, he undertakes to complete the unfinished work. Because
Yeah, they also are admitting that it was
yeah,
unfinished.
it was unfinished, but when the criminal trial was in the proceeding and when the writ petition, criminal petition under 482 challenging the FIR to be quashed and the charge sheet file in the case has to be quashed, they have insisted to the court that they want to continue with the work and do the incomplete work, to finish the incomplete work. So, by order dated 28/11/2024, during the pendency of the criminal petition,
That earlier.
that
criminal-
earlier, the order was given by the court
to complete.
complete. So,
Order dated
28/11/2024.
11/2024.
That is in connection with criminal
In
petition
criminal petition
41, 42, and 43.
41, 42, 43 of
2024.
2024. Allowed the petitioners to complete.
Yeah.
Petitioners to complete the work. Is that order on record?
Here it is in the writ petition, in the criminal petition, it is not enclosed. But in the other criminal petition, it is the court record is there, the official order is there.
Can you supply a copy of that order also later?
My lord, my lord.
Yes. Order dated 28/11/2024. Yes, then?
Yes. So therefore, works executed and completed
The
after the,
proceeding, if I may, the proceeding on that day, in order to just to not in order not to come back to this issue again, on that day we made a submission to petitioners that the structural works of the main High Court building is now complete, and then the encircling part is about to be executed. And reflecting our submission, yes, the order was passed. It was not that the court directed without our submission. Yes.
Okay.
Otherwise, it would seem as if it was we were made to perform as a punishment. It was not like that. We ourselves gave the status of the progress of the structural works of the main High Court building, and then that at this stage, yes, that was it.
so whatever that the work executed on the part of the order passed by this Honorable Court in the other criminal petition, otherwise during the proceeding of the main case, that should not come within the purview of this Honorable Court. That's what I'm trying to pinpoint, because here all these issues are not relevant to be discussed by this Honorable Court under criminal revision petition. I've also stated about the maintainability of this criminal writ petition also. To that legal aspect, I'll come later on. But in order to assist this Honorable Court, I'm just trying to come to the certain crucial facts. So based on the entry of the measurement book, the amount were received in release. There was no proper entry in the measurement book. So I would like to take your lordship to page 93 of the criminal petition. Page 93, relevant para is 16.18.
Page 93, 16.18.
18. I may be allowed to read out. For better understanding about the measurement book in respect of the land of the road, it is to mention that the starting point of the measurement was taken as identified by the accused contractor and the concerned engineer of the NPWD RNB. And the end point of the measurement was taken at the point where the premise carpet of the road ends just at a distance of 10.40 meters from the nearest edge of the main High Court building. The actual length of the road is found 1,663 meters as against 2,010 meters recorded in the MP book against 2,000 meters as per the work order. Yesterday I was emphasizing on this also. As per the work order, it is only for 2,000 meters.
Actual length of the road from this.
Then again, 16.20.
Okay, so what you're trying to say is the actual length of the road was only 1,663
2,000.
meter.
2,000.
2,000.
It is only as per the country.
No, here you have stated it is stated in the 16.8,
Yes,
18.
yes.
The actual length of the road found is 1,663 meter.
Only that much was.
So that's why I'm saying. What you are saying is it was only 1,663 meter, but in the MB book it was recorded as 2,010.
Yes.
And in the work order it was 2,000.
Yes.
So 10 meters extra.
Yes. .20. Whereas investigation could gather the following evidence which prove beyond doubt that the accused contractor had constructed the road only up to the point of the High Court complex where the premise carpet of the road ends just before reaching the main High Court building as mentioned above, and no such circular with checkered tiles footpath had been constructed beyond the said endpoint. Clause 1. Chief Engineer NBWD RNB, White, his letter dated 25/1/2021, has informed about the non-availability of availability on records regarding the proposal in approval of the competent authority to demolish/dismantle the premise garbage road with checkered tiles footpath said to have been constructed and the said have been demolished/dismantled while leveling the land for construction of the main High Court building. Clause 2. The Secretary, Department of Law and Justice, Brigade User Department, White letter dated 1/2/2021, and the Chief Engineer NBWD Housing, White letter dated 22/1/2021, have also given the same information as provided by the Chief Engineer NBWD Brigade RNB above. Number 3. So for 3, it is not convenient. It is not relevant in this case. So I'll skip this 3 also. 4. One of the pleas taken by the accused contractor is that though the work order was issued in the month of February 2008, so it was January. The construction of the road with premise carpeting had been done before the laying of the foundation stone of the High Court building on 21/5/2007. 2007. That means without the issue of the work order, the work was executed. Work order was issued only on 2nd February 2008. But the work was already done in 2007. I don't know under what basis, under what terms and conditions the contractor had executed all this work. This is very crucial aspect that the court has to look into. Yeah. Foundation stone of the High Court building on 21/5/2007 by the Honorable Chief Justice of India and presence of the Chief Minister of Nagaland and other dignitaries. However, some photographs of the said foundation which were seized during investigation of the case clearly shows that there was no premix carpeting on the ground/area of the High Court complex. Here, so coming to the point. Concerning with the distance in measurement, all this, the contractor or otherwise the engineer has manipulated beyond the work order for which the government officials in the accused petitioner in criminal conspiracy had misused the fund. Now, further, the entries made in MPBO were not in conformity. Page 99. Yes.
Which para?
Page 99, para 16.24.
Yes.
I may be allowed to read out. Investigation revealed that the first RAPL for rupees 14403,250 and corresponding false entry in MPs were prepared by the accused Massively Savino A. Dan, GA, which were countersigned in past for payment by accused, namely so-and-so, A3, EE. The second running bill for rupees 422,75,920 and corresponding false entries in MP were prepared by the accused engineer Massively A. Dan, GA, which is countersigned in past for payment by accused Mr. So-and-so A4 EE. Whereas the third running bill for rupees 481,01570 and corresponding false entry in MP were also prepared by accused so-and-so, but countersigned by the accused Nimu Kak E8 is due and passed for payment by accused so and so A5 EA. So this is the thing that the investigation has detected. Then 16.25. It may be mentioned here that though the FIR name accused Mr. So and so A7 had not prepared any of the said 1, 2, 3 bills, running bills, and had not made entries in the corresponding MPs, he was otherwise working as concerned STO of the work with effect from 2006 to 2010, and hence he cannot escape from the liability for such substandard construction of the road resulting in excess payment of the contractor due to shortage in length of the road. So this is the clues that they have found during the course of the investigation. A person who was not working, they have signed the MB books, otherwise they have signed the checks. But the person who was supposed to sign all this was Mr. Nimukhat, who was working from 2006 to May 2010 when the work was under execution. 16.26. Investigation revealed that the amount of 467,855 check number so and so. So this are the crucial facts that the amount, the CBI as well as the petitioners, they are in coincidence that they agreed to this amount. The whole amount that the contractors have received, and because of those anomalies completed in the MP books, the petitioners as well as the accused contractors, officials, he in criminal conspiracy has misused the fund. Thus, the meeting of mind between the accused petitioner and the government officials are clear ingredients to prove the criminal conspiracy under 120B IBC. And there was a misappropriation of 29,68,395, constitute the cheating under 420 of the IPC. My lord, here in the present case, though the work order was to be completed, yesterday I was emphasizing on this issue, but it is also important, that's why I'm coming back again. 12 months was the period to be completed, which the work order has been annexed at page 55.
55. Yes, we have seen that. 55.
Yeah, yesterday we have referred to that also. Now, but not completed since the time of the order passed by the Honorable High Court in PIL Somoto number 5 of 2017.
Yes, what did you say?
Yes. Here, the work order was issued on 2nd January 2008.
Yes.
And it was supposed to be completed by 12 months, as per the agreement and work order. But by that time, it was not completed. That is some other relevant issue involves rain. But here, when the Honorable High Court, Principal Bench, took up the Somoto PIL number 5 of 2017, only at that time the issue has come to the limelight of the entire case, how the High Court construction was going on. In a snail pace, whatever basis, how, for what reason, because of mismanagement of the fund, or there are certain reasons which I don't like to highlight here in this, because we are just confining to this case. Had there not been the said PIL, my lord, had there not been the said PIL, what would have been happened or prevail of this running High Court construction, new High Court construction? Even after the filing of all this, now the issue is coming up and it's going on to this extent. Very sorry for all of us that even Nagaland, we cannot inaugurate our own High Court, despite of the fact that the same High Courts were in the same period of time was allowed to be constructed. They have started independent High Court at Sikkim or otherwise in Manipur also. Same period of time, our Honorable High Court was, Kohima Court was also then allowed to be constructed and a sanction was made. Now, yesterday, my learned friend, he was also pinpointing to the point that failure to execute the contract work within the stability period amount to breach of trust and breach of contract. He said there was no breach of trust and breach of contract. I'm saying that in this case, there is a breach of trust and breach of contract. Though civil in nature, the work that the petitioner they have executed, it was in civil nature, but because of the present BIL and the upcoming RC2 of 2019 concerning with the prison case, the color of the case is now turned into a criminal case. And I would like, for that, I would like to make a reference to this Amit Kapoor versus Ramesh Chandra, 2012. 2012, 9 ACC. (2012) 9 SSC 460.
Page, para?
Page number is 461. I'd like to, for easy reference, let me come to this head note if, the top part of page 461. Criminal Procedure Code 1973, Section 482, 401, 397, and 228, Quashment of Criminal Proceeding. Civil dispute involve as well effect of criminal proceeding if abuse of process issues really being only of civil dispute, determination of when a ground for quashment of the criminal proceeding reiterated where existence of civil disputes would not by itself alter status of the allegation constituting criminal offense. For quashment of the criminal proceeding allegation to have to be so predominantly of the civil nature that they would eliminate criminal intent and liability. So this is one of the crucial discussion that the Supreme Court has emphasized in this connection with the civil nature of case, which has turned into a color of the criminal case. It has been emphasized. This particular judgment, I'll be making a citation in reference and I'll be reading out at the legal aspect also. So at that point of time, the if note, it will be clearly pointed out by me also. Now here, my lord, whatever the ground that they have said in their criminal petition from at page number 39 to 50, ground said at A to Q, there is no merit, my lord. There is no merit. In the eye of law as well as in fact, as there is no propriety, illegality, jurisdictional error committed by the trial court while disposing of this, the IA 59, 60 and 61 of 2025. That is their discharge petition. That which we have referred yesterday. The discharge petition where the trial court has already disposed and dismissed here prior by emphasizing on one of the most crucial judgment, that is Sachin Kumar versus CBI. My learned friend, he's been admitting on that. The analysis that has been adopted by the trial court below, everything he has admitted, but he yesterday clearly indicated to this before this honorable court that it was not on the basis on the basis of what he has think. So how can the court can proceed ahead on the basis of when the counsel thinks that his point of view has to be taken into consideration? And even in the grounds...
No, this court will only examine whether the learned trial court has interpreted the judgment in the correct way or not.
That is, so I'll come to that. Because this portion, what I'm just trying to make out is that these are factual aspects, but I'm now coming to the point of the petition that they have set out the grounds. My learned friend, he has never emphasized on that grounds till yesterday. From ground A to Q, he said that these are the so many grounds that he has set out because of this and this. But if we are to look into the grounds from A to Q, not a single illegality, jurisdictional error, or propriety has been pointed out by the petitioners in the revision petition. Now I'll come to the law and legal aspect, my lord. It is very important to understand the meaning of the discharge under CRPC or BNNS Act. In legal parlance, once the accused is discharged, then the accused is free from all criminal liabilities. Culminates the criminal trial, and the accused can be treated as innocent. If no discharge means the criminal trial is set on motion by framing charge. Yesterday I was saying that if they are innocent, if they are saying before this honorable court that they are innocent, why not they face the trial so that the trial can proceed in an expeditious manner and get an honorable acquittal? That is what I'm trying to pinpoint. Because every order passed by the court, special judge, otherwise the CGM, they are challenging the orders, which only try to stalemate the proceeding, otherwise to prolong the case. Reiterating once again, the special judge CBI Dimapur, Nagaland, after considering the material evidence in the entire aspect of the case in hand, had dismissed their discharge petition filed by the accused and relegates the case to the CGM Dimapur, Nagaland, to proceed with the case under Schedule Offence 120P and 420 IPC. After a failing effort by the accused petitioner before the High Court by filing criminal petition under 482, the accused appeared before the CGM Court Dimapur, wherein again the discharge was filed, which was also rejected after scrutiny of the documents and other evidence collected by the CBI against the accused person. So, no irregularities has been committed. Why I'm saying both? Because the special court has given a finding and relegate the matter to the CGM to proceed ahead with the case. So, in both
we have to remember that at that point of time, before the special judge,
yes,
the engineers were also there.
Yes, at that point of time,
the engineers along with the contractors, all of them were there.
Very much. Yes, it was.
But now the engineers are not there.
Yeah, they are not.
So only the petitioners.
Yes. So here, in the criminal petition, they have been challenged. They have challenged the order passed dismissing their discharge, that is 18/2/2026. On the same day, charge was framed. They are challenging that also. On the same day, the order was passed by the court summoning the PW1 and fixing the date as for 13/4/21 for evidence. That has been challenged. So here, all those orders challenged by the petitioner in this criminal petitions,
This is a revision.
Yes. Revision, sorry, I'm so sorry. Revision petition. No illegality has been committed by the trial court. That is, jurisdictional error has been committed by the trial court. That is what I'm trying to say also. Under section 482 and 442, PNACs corresponding to the All Act, that is 397 and 401, my lord. It is a widely acknowledged standard, and it is that the higher court revisional authority is extremely limited and cannot be used for on a routinely basis. Criminal revision under 42442, that is the section that they have invoked, and 438, that is under PNACs, and the All Act under CRPC is 397 in respect of 438 of the new, and 401 in respect of the new Act 442. So every paragraph, every provisions, schedule, or the wording are all 100% same in this new in the PNACs and the CRPC. Now, to assess this honorable court, certain guidelines has been given by the Supreme Court in connection with the exercise of the criminal revision also, my lord. At pre-trial stage, the High Court are directed to refrain from minutely analyzing evidence. So this court is not the court of trial who has to adduce the evidence. The court is not only required to see if there is, the court is only to see prima facie case. Only prima facie case. Strong presumption. And the suspicion of the guilt based upon the material produced by the prosecution. Under PN's framework, the legal standard governing the petition operate as follows. Scope of 442 revision. Section 442 gives the High Court power to examine the correctness, legality or propriety of the lower court's order. So I'm saying that there is no illegality, propriety or anything. The Supreme Court has repeatedly held that order refusing to discharge is largely appealed if the disputed facts are substantive and can only be evaluated during trial. Disputed question of facts. Now here there is a disputed question of facts also involved, the amount, concerning with the amount. If the trial court's order was well reasoned and noted that a prima facie case exists, the High Court should rarely interfere in the revision petition. The established jurisprudence dictates that the accused cannot seek discharge simply by denying the prosecution allegation at this primary stage. Prevention of miscarriage of justice. Revision is not an appeal. Higher court will generally only intervene to correct patent illegalities, severe jurisdictional error, or manifest injustice rather than re-evaluating evidence from scratch. Power of interlocutory orders. This is one of the kind of interlocutory orders. I honestly admit before this Honorable Court that there are three orders. One is the interlocutory order, one is the final order. And there is, as per the decision of the Supreme Court, there is one intermediate order. I'll come to that while I'm discussing about that order also.
No, but order discharge and order framing charge is not interlocutory because it affects the right.
That's why it is not a final order because it never amounts to the conviction or acquittal of the accused person also. So it is.
Of course.
Yes.
But
intermediate order. Supreme Court explains what is the intermediate order. So my contention here is that 442. I'd like to take you to this section 442 also.
BNSS.
May I read out? 442, High Court Power of Revision, Clause 1. In the case of any proceeding, the record of which has been called for by itself or which otherwise comes to its knowledge, the High Court may, in its discretion, exercise of any of the power conferred on the Court of Appeal by Section 427, 430, 431, and 432, or on the Court of Citizens by Section 344, and when the judge composing the courts of revision are equally divided in opinion, the case should be disposed of in the manner provided by Section 433. Now, these are the saving clause of sections, provision of law, covered by 442 under revision. If we read out this 420, 427, 430, 431, 432, all these are concerning with the acquittal, sentence, and conviction. My Lord, for the better understanding, I would like to turn to section 427 for better understanding. Please don't take it in other sense that I'm trying to teach this honorable court, but in order to get a better understanding, 427, which has been covered under, provided under section 422, power of the appellate court. Under section 422, the first provision of law indicated is 427, power of the appellate court. After perusing such record and hearing the appellant or his advocate, if he appears, and the public prosecutor, if he appears, and in case of appeal under 418 and 419, the accused, if he appears, the appellate court may, if it's considered that there is no sufficient ground for interfering, dismiss the appeal, or may, number A, in an appeal from the order of the acquittal, reverse such order, direct further inquiry be made, or that the accused be retried or committed for trial, as the case may be, or finds him guilty and pass sentence on him according to law. This picture does not come with in the case of the present petitioners. So 427, it never comes. And whatever that the sections that has been indicated under 442, all those 4 sections are in connection with acquittal, sentence, conviction. So when the power of appeal has been provided under 422 also, no doubt, during the stage of the appeal, if in any interlocutory order has been passed by the court, in that situation only the court can exercise power under 422. So 422, which has been invoked by the petitioner in the present criminal revision, is not maintainable. That's what I'm trying to pinpoint. 442 particularly. The part if the
No, 442 to be exercised only when it's not appealable.
yes. So here the question does not. It is. I'll come to 438. I'll come to 438. There is a clause. When it is in interlocutory order, the interlocutory order cannot be challenged. That is one part. There is one part. I'll come. Because first I would like to complete my submission, confining with 442. And just to save this honorable time of the court, let me not read out other sections. 430. 430 is also, if the court permits, I'll just continue reading for better understanding also. 430.
No, 430 is suspension
Suspension,
of sentence.
yes. So the present situated case
No,
does
that
not
is different.
falls within this also. Then 431, even though I don't need
That
the
is
entire
also
context,
arrest.
arrest,
That is different.
that is different. Then 432,
Additional evidence.
yes. So the High Court can exercise within the preview of this, the revision, otherwise the Citizens Code under 344. It is the Act is very clear. The provision of law is very clear. So 442 cannot come into play in the present case. Now, the part on interlocutory orders. Yes. So, one way I'm saying that dismissing the discharge petition and passing for order for framing of the charge summoning, they are all interlocutory orders. That is what
You're trying to
my argument, point of argument, but I'll come to the later part how I assist this honorable court also. So interlocutory order cannot be taken into challenge under revision. In a routine procedure, my lord. Framing of the charge, summoning of witnesses. No conversion of acquittal or conviction. So it is this particular provision relates to 444. So I'll not emphasize on that much. Exhaustion of statutory remedies. A revision petition will ordinarily not be entertained at the instance of the party who had a statutory right to appeal but failed to utilize it. So that is one aspect that 442 says. Mandatory opportunity of being heard. So all these are the principles that the Supreme Court has established and given the guiding principles to the subordinate court how to follow all those things. Then I would like to place a reliance in this, the one that I earlier referred, 2012 9 SCC.
This
Page,
one.
yes, the first one that I've just referred to the head note F. relevant para is 12, my lord. May I read it? Section 397 of the code vests with the power with the vests the court with the power to call for and examine the record of an inferior court for the purpose of satisfying itself as to the legality or regularity of any proceeding or order made in a case. The object of the provision is to set right the patent defect or an error of jurisdiction or law. There has been to be a well-founded error, and it may be appropriate for the court to scrutinize the order, which upon the face of it bears a token of careful consideration and appears to be in accordance with law. If one looks into the various judgments of this court, it emerges that the revisional jurisdiction can be evoked where the decision under challenge are grossly erroneous. There is no compliance with the provision of law. The finding recorded is based on no evidence, material evidence is ignored, or judicial discretion is exercised arbitrarily or perversely. Thus are not exhaustive classes, but are merely indicative. Each case would have to be determined on its own merit. So in this case, there are numbers of evidence amassed by the prosecution that the court below, that is the CGM, has passed the order on the right legal perspective. Then again, para 13, it may take some time for citing the judgments and reading out the judgment also, but
You just give the relevant paras
yeah,
otherwise.
and otherwise also, as insisted by this honorable court, if we can provide a written argument, I've prepared. So everything is clearly indicated.
That is also good.
Just to save the time, I
And
can
then you
reflect.
give the relevant
Yeah,
paras
relevant
also.
para, everything I've given. So that is one aspect. Again, I would like to rely on, let me just continue with the citing of the paragraphs, my lord, so that the court can take note. In this 2012 9 SEC 460 relevant para is 12, 13, 14, 16, 17, 18, 19, 20, 21, 25, 29, 30, 36, and 37. So while coming to a conclusion of this case by the Honorable Supreme Court, the accused were directed to face the trial, and the revision was dismissed. The revision which was been referred by the appellant, it was dismissed. Another judgment, my lord. This is a judgment which has been relied by the CGM court also. Sachan Kumar versus CBI 2010, then SEC, page 368, my lord. Relevant para is 5, 19, 20, 21,
Wait,
yes,
5, 19,
sorry, 20,
21.
21, 22, 23, 24, 40, 43, 44, and 45. Here the Supreme Court has analyzed the entire
Wait.
yes
2010, then SEC.
368 68 page.
368.
Yeah, 368. That is Sachin Kumar
No.
versus CBI.
Something is wrong. 2010, then SEC. 2010,
Oh,
then SEC.
my lord, I'm
368.
so sorry, not 2000.
No.
368.
2009 SEC. I'm so sorry. I'm so sorry.
So this is a different one.
Yes, so sorry.
2010 9 SEC.
Yes,
368.
yes. That is, it was a typing error.
Okay. 5, 19, 20, 21, 22, 23, 24, 40, 43, 44, 45, and
Yeah,
till
45.
45.
Yes, till 45. Even in this case, although the Supreme Court has given a direction to the court to conduct the trial, and the petitioners were directed to approach the court. There's another judgment, Tharonti. I'll provide a copy. Tharonchi Tichpal versus State of Goa and another 2019 INS 918. So I've marked, so just to save the time of this honorable court, I'll provide a copy of that. Here there are three printout judgments which I will reference, but I've indicated, I've marked with the blue ink. And in my argument, after my completion, I'll provide the argument that I've relied also. So, if the paragraph of all this has been is analyzed, and if taken into consideration, the revision is not being permitted, and the Supreme Court, Honorable Supreme Court has dismissed their revision petition and directed the accused to face the trial. So here, one crucial aspect is that I've already narrated about 442, the review does not fall in this case. 438, that is another ground, section of law TF invoked. So here, I have given the I've provided Ravi, there is a printout that I provided to you also. That I'd like to rely on that also. Supreme Court in 2024, INS C 462, K. Ravi versus State of Tamil Nadu.
2024 INSC.
Yes.
642.
642. K. Ravi versus State of Tamil Nadu and another, which was decided on 24th August. So I may be allowed to read out the paragraphs. It's not that much also, but it is very crucial also. If your lordship can peruse the printout that I provided in the clip.
No, this one is that Tarun Tejpal.
Yeah, but in the big side, if you open the clip, the judgment
there
that
are two here.
Yes.
Okay, okay.
Para 4. This is a similarly situated case. That's why I would like to read out this thing. Shall I? May I continue? The investigating officer, after collecting sufficient evidence against all the accused, submitted charge sheet implicating 31 accused before the Court of Judicial Magistrate who committed the case to the Court of Sessions for trial. Para 5. The respondent number 2 filed an application before the Sessions Court seeking his discharge from the case under 227 of CRPC and the said Session case, which comes to be dismissed by the Sessions Court by order dated 1/7/2016. The said order came to be challenged by the respondent number 2 before the High Court by filing a revision petition number so and so. The said revision application came to be dismissed by the High Court by order dated 5/8/2016, specifically holding that there were no sufficient incriminating materials available against the respondent number 2 to frame the charge, and the Sessions Court had rightly dismissed the application filed by the respondent number 2 under section 227 CRPC para 7. From the above conspicuous of events, it clearly transpired that the respondent number 2, after having failed to get discharge from the Sessions Court as well as from the High Court and the first round of the litigation, filed another vexatious application before the Sessions Court under Section 2164 CRPC after the framing of the charge by the Sessions Court for modification of the charge. The Sessions Court, having dismissed the said application, the respondent number 2 preferred a revisional application before the High Court under 397 and 401, that is the old Act. New Act is the provision that they have invoked, 442 and 438. The High Court, in its unusual impugn order, discharged the respondent number 2, A2, from the charges leveled against him, though his earlier application seeking discharge was already dismissed by the Sessions Court and confirmed by the High Court, and that the possession has attained finality. The High Court utterly failed to realize that the order impugned against it was the order passed by the Sessions Court rejecting the application of the respondent number 2 seeking modification of the charge frame against him under Section 216 of CRPC, and the said order was an order of interlocutory in nature. Para 8. It is pertinent to note that the order dismissing application seeking modification of charge would be an interlocutory order in view of the express part contained in subsection 2 of Section 397 CRPC. So the new provision under PNSS will be 438. So I'd like to take your lordship to Section 438 also.
No, this is different. This is application for modification of charge.
Yeah, but the revision where the High Court can exercise is under 438, the provision that the petitioner has invoked also. And here 397 is reflected because it is in OLEC. Now, in the new...
Question altogether.
Huh?
It's on a different question.
No. But I'll come to the... I'm just saying that...
No, what this Supreme Court is saying in this is, modification of charge application is an interlocutory order.
Yes.
So revision could not be maintained.
Yeah, that is one.
That is what it's saying. No. But in this case, it is not application for modification
It is not.
of charge.
But by taking this 397, which has been reflected by the Supreme Court, here I would like to come within the preview of the criminal petition that they have invoked. 438 and 397 is the same section, only renumbered. In PNSS, it is 438. In CRBC is 397. So the decision which has been rendered here is in respect of 397. Now I would like to take your lordship to this 438. May I read it? Calling for records to exercise power of revision. Number 1, the High Court or the Sessions or any Session judge may call for and examine the record for in proceeding before any inferior criminal court situated within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the regularity of any proceedings of such inferior court, and may, when calling for such records, direct that the execution of any sentence, order be suspended, and if the accused is in confinement, that he is to be released on his own bond or bail bond pending the examination of the record. So this clause 1 does not attract that it also in this case. Even they have invoked 438 also, but clause 1 does not comes within the preview of this criminal petition.
How? Record of any proceeding?
Yeah, concerning with this, my lord, may, if your lordship may come to this last 3 paragraphs, and me, when, above that also, itself or himself as to the correctness, legality, or propriety of any findings, sentence, or order recorded or passed, and as to the regularity of the proceeding of such inferior court, and may, when calling for such record, direct the execution of any sentence or order to be suspended. And if the accused is in confinement, that he has been released, that he has to be released on his own bond or bail bond pending the examination of record. So they are not in confinement. Explanation: all magistrate, whether executive or judicial, and whether exercising original or appellate jurisdiction, shall be deemed to be inferior to citizen charge for the purpose of this subsection and section 439. Clause 2. The power of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, or other proceedings. So this clause 2 gives a little scope. Why I'm saying it, there is little scope, because I'll come to one judgment which I'll place before this honorable court. The Supreme Court expressed three kinds of order. One is interlocutory, the other one is the final order, that is the finality. But when it is neither an interlocutory nor a final order, it is termed as intermediate order. So, despite of the fact that not a single voice has been, not a single word has been whispered in the petition, in the criminal revision petition, I'm saying that these are all interlocutory, but let the court may analyze whether the present petition will succeed or will not succeed. It is to the wisdom of this honorable court while deciding the issues. But here I'm saying it's not maintainable. Clause 3. If an application under this section has been made by any person, either to the High Court or to the Sessions Court, so only one petition, so number 3 does not comes within the preview. Then I was making a reference to this K. Ravi versus State of Tamil Nadu, the printed one that I provided in para 9. Kindly come to para 9.
Which one?
K. Ravi
K.
versus.
Ravi.
Yes.
At this juncture.
Yeah, at this juncture, it would be apt to refer to the observation made by this court in Amit Kapoor versus Chandra in another the judgment that I already referred. That is Supreme Court judgment 2012. Explaining the scope of 397 CRBC, it was held that 397 is equivalent to 438. 12 section 397 of the code rests with the court with the power to call for and examine the record of an inferior court for the purpose of satisfying itself as to the legality and regularity. So that I've already read out. Let me skip this para 9. Para 10. Thus, the scope of interference in exercise of jurisdiction under section 397 CRPC is extremely limited. Apart from the fact in subsection 2 of 397 prohibits the court from exercising the power in revision. Even the power under subsection 1 therefore would be exercised very sparingly and only where the decision under challenge is grossly erroneous or there is no compliance of the provision of the law as the finding recorded by the trial court is based on no evidence. No material evidence is ignored or judicial discretion is exercised arbitrarily or perversely by framing the charge. The court exercising revisional jurisdiction under 397 should be extremely circumvent in interfering with the order framing of charge and could not have interfered with the order passed by the trial court dismissing the application for modification of the order so-and-so, which order otherwise would fall in the category of an interlocutory order. 11. It is a try to say that section 216 is an enabling provision which enables the court to alter or add to any charge at any time before the judgment is pronounced, and if any alteration or addition to the charge is made, the court has to follow the procedure that contained therein. Section. So it is concerning with the charge deletion or addition, and let me not confine to that. But even the revision is not permissible in this. 12. So far as the facts of the present case are concerned, as stated herein above, the respondent number 2 has miserably failed to get himself discharged from the case in the first round of litigation when he had filed the application under 227 CRPC. Still, however, he filed another vexatious application seeking modification of charge under section 216 of CRPC to derail the criminal proceeding. The said application also having been dismissed by the Sessions Court, order was challenged before the High Court by filing another application under 397 CRPC. The High Court, on an absolute extraneous consideration in utter disregard to the settled legal position, allowed the revision application filed by the respondent number 2 to legally untenable and set aside the charge framed by the Citizens Court against the respondent number 2. The said order being ex facie illegal, untenable, and dehours the material of the records, the same deserves to be set aside. Para 13.
This judgment is not applicable, Mr.
My Lord,
PP.
now I'll come to the
this-
conclusion part.
This is a case where the petitioner had moved an application for alteration of charge,
Yeah, that-
modification
that-
of charge, and that was dismissed. Dismissed. So now the Supreme Court is saying that was an interlocutory order.
That was an
Yes.
interlocutory.
So this is not.
Now
this
here,
is not
why-
framing of charge. It is not discharge, dismissal of discharge.
No, my Lord.
Facts are totally different.
My contention here is that I've already submitted. The petitioner, they are challenging every order passed by the court below. That is on that line I'm coming up. But in this case, whatever the petition, discharge petition or the notification and so, it was not allowed under the revision, and the petitioner in this case who have been directed to appear and face the trial.
Because the modification was not allowed.
Yes, modification was not
The
allowed.
modification of charge was not allowed. That is different. Yes, then next.
So, since I'll be submitting the written argument and by reflecting the entire paragraph, I'll provide to this your lordship. My argument has come to an end. So, here the petition, revision petition is not maintainable. But by abusing the process of the court, abusing the law, they have filed this revision petition before this honorable court, seeking quashing of the order passed by the CGM, that is the discharge petition, which was rejected, framing of the charge, which was under challenge, then issue of summon to the PW. If when the discharge is not been allowed, the procedure that has to be adopted by the court below has to.
So
forgo.
according to you, then what are the intermediate orders?
Yes, that I'll provide the I have a judgment.
Because there are so many orders where in orders rejecting discharge, framing charge, issuing summons, revision has been entertained. And
It
those
depends
have been
upon-
upheld.
It depends
Yes.
upon the case. I leave to the wisdom of the Supreme Court. But here, this
But
is one
since
of
you
the
are
judgment.
mentioning about
Yes.
intermediate, so let's see.
Kerish, I'll provide, my lord. Kerish Kumar Sunija versus CPI, 2017. This is equivalent citation is in EIR 2017 as is Supreme Court. I'll just provide, my lord, so that Lordship can use this. It explains about intermediate order.
So what are the intermediate orders?
Intermediate
according
order
to you?
is of a similar nature. Of this, when the discharge has become not been allowed, they are not treated as a intermediary. They are not treated as a interlocutory nor as a final, but it falls within the preview of intermediate. I only one copy.
27.
Yes.
The marked ones.
Mark ones, it explains there. Due to paucity of time, this morning I could not get the entire marking and get the zeros. But there it explains, so I lift the wisdom to this honorable court. But my contention is that when the order passed by the CGM does not exceed its jurisdictional error, it is legal, no arbitrariness has been committed, impropriety has been committed. Based upon the material documents amassed by during the investigation and has been filed before the trial court and during the examination and hearing of the discharge, the court has come to a clear conclusion that there is a grave suspicion and a prima facie case has already been found out. So the prayer of the petitioner in this revision petition should not be allowed and they are not maintainable.
Yes.
My lord, my learned friend for the CPI, if he addressed the issue of maintainability first, and if that was the correct position of law, then we would not have wasted time since yesterday. Now, my lord, the issue regarding 397-401, the Supreme Court in 2022, 15 SCC, 720, in paragraph 14.
Paragraph 14.
Yes, my lord. They have relied on another Supreme Court decision. The correct position of law is laid down in
This is your argument.
Yeah, that is just formally that I forgot. So for referring to the paragraphs and the judgment, if the court can have an access.
Yes, paragraph 14.
The correct position of law is laid down in Matulimai, which is reported in 1977, 4 SCC 551. Thus is that orders framing of charges or refusing discharge are neither interlocutory nor final in nature and are therefore not affected by the power of Section 397(2) CRPC. That apart, this court in the above cited cases have unequivocally acknowledged that the High Court is imbued with inherent jurisdiction to prevent abuse of process or secure ends of justice, having regard to the facts and circumstances of individual cases. Therefore, there is no legal power.
Yes.
Yes, and in my humble opinion, the submission made by my learned friend is misconceived. I may be permitted to reply in brief the submissions made by my learned friend since yesterday. I'll be as brief as possible. Now, firstly, my learned friend has taken the ground of stare decisis that the order passed by the CJ may have been already covered by the principle of stare decisis since there is an earlier decision passed by the Special Judge CPI. Yes. Now, my lord, we have approached this honorable court by filing criminal petitions 41, 42, and 43, and which has already been allowed and discharged. We were also given the liberty to file discharge petitions before the learned CGMT Mapu. And against that order, the CPI has no legal grievance. Till now, it has not been challenged before any higher court. And as such, that issue does not exist.
No, that's why I said that has attained finality.
Yes, yes, my lord.
Because that is now a closed chapter.
My lord, my lord. Now, my lord, secondly, he has stated that the petitioner is trying to, the petitioner instead of trying to prolong the hearing of the case should face the trial and get an honorable acquittal. My lord, as I have placed a decision yesterday, 2015 3 STC 123, that criminal proceedings have far-reaching consequences. And that summoning of an accused in a criminal trial is a serious matter. And unmerited criminal prosecution is an infringement of fundamental right. And as such, when they have instituted an unmerited criminal prosecution, they cannot say, why are you not facing the trial? That would amount to the abuse of the process of law. Thirdly, my learned friend has pointed out that as per the measurement book, which of course the government engineers have maintained, there is an entry of 2010 meters, whereas in the work order, it's only 2000 meters. Now, firstly, before I go to the rulings, by common sense also, well, if it is short by 10 meters, will the government also issue tender for that 10 meter? Who will participate in the tender process for those 10 meters? As such, some fair play in the joints is being awarded to the contractors.
No, that is off the record. He is trying to counter.
No, but assuming that, even assuming that the entry made in the measurement book is true, even then, that is what I am saying. Of course, it is not admitted, since I am not privy to it. But even assuming it is true, even then, now, my lord, in 2020-16 STC 489, para 19. The law laid down in Tata Cellular has been reiterated that fair play in the joints must be given in contract matters. Otherwise, my lord, I may be permitted to read para 19, the relevant portion. As laid down in the judgment cited above, the courts should not use a magnifying glass while scanning the tenders and make every small mistake appear like a big blunder. In fact, the courts must give fair play in the joints to the government and public sector undertakings in matters of contract. Courts must also not interfere where such interference will cause unnecessary loss to the public exchequer. The Supreme Court is echoing the celebrated judgments, the celebrated principles laid down by itself in Tata Cellular versus Union of India, which is reported in 1996, EIRSC 11, para 113. I may not read that para in order to save time. Now again, regarding the percentage of taxation. Of course, TDS is being deducted and other taxes are being deducted. My lord, but one thing is important here. This work order was issued prior to GST being implemented.
No, I've not mentioned GST. I mentioned CST, Central Service Tax.
But be that as it may, whatever taxes have been, we have that the same has been deducted, which is very much visible from para 16 point, maybe 60.28.
$16.28
Yes, my lord.
against the third RA bill amount.
Yes, 4,81,01,570. So out of this, I have received the amount that I have mentioned in my petition at paragraph 3, that 4,52,99,286, that is after taxes. So there is no disputed fact as to how much I have received, which has also been admitted by the CBI.
Your Honor, here, when there is no records to prove all this aspect.
No, you have admitted in your affidavit.
I'm admitting to the affidavit to the extent of you receiving 4,52,900.
Yes, yes, of course.
But not to this amount. It is being denied
No, the court will not go into all
Yes,
this.
yes, it is.
We will only see
Whether there is a
whether,
legality or illegality
yes,
committed by the
that's-
trial
that's all,
court.
that's
This is not the court of evidence.
That's all.
Now, my lord, in the CPI in the paragraph 3, which I have pointed out yesterday also, they have admitted this amount that I have received, 4,52,99,286, and in the charge sheet at paragraph 16.28, the amount with prior to deduction of taxes is given.
None of you have addressed the issue regarding the ingredients of
I have
420.
my lord, I have yesterday.
Because ingredient is at the inception that
Yes,
dishonest
yes.
intention has to be
Yes,
there.
yes.
Number one.
In my though I on that particular ingredients, though I have not given orally, in my written argument I have clearly indicated. And if the court permits, I'll just make a reference and
No, if it's there, it's okay.
yeah,
Here,
it's
yes, it-
provided in my.
I have made the submission that the ingredients were not
Yes.
satisfied. However, I have not placed the ruling yesterday.
First is that that dishonest intention
Yes.
from the very inception
Yes,
that has to be there.
yes.
Yes.
Now, my lord, deceit has to be practiced the ingredients. Deceit, if it is practiced, then it has to be caused. And if deceit is caused, then thirdly, due to deceit being caused, there must be delivery of property. Now, my lord, here there is no deceit. We are bona fide, genuine government registered contractors. We have participated in the tender process and we were awarded the contract. And for the work executed, we have submitted our bills. In the bills, there is our signature, we don't deny it. And for the work executed, the amount has been paid to us. And for the work not executed, we never claimed, it was never paid to us. After the completion of the work in 2025, we have written a letter to the government to release the amount of 1,91,000 something.
So this 2024-12 ACC is for?
Ingredients of offense, my lord.
Okay.
Of 420.
Para?
Para 22, my lord. In order to save time, I may
Then,
not.
don't read.
Yes. My lord, now, secondly, so far as 120p is concerned, the allegation is that there was a connivance with the engineers. Now the engineers are no longer in the case. And we are one and the same person under the law, being partners of the same firm.
My lord, that aspect, though the prosecution sanction was not being granted, they have been exonerated in one sense, in that case. But the role has been played by both the sides, contractor and the officials.
But 120 needs two parties.
Yes.
That's why, two parties.
When
And
there's only one, then what
That's why
happens? Then
here
does
in this case-
120B still exist? That's what I'm telling.
that is why, though, if the prosecution was sanction was granted to the government
But
officials.
now we are dealing with a situation where there's no sanction.
No sanctions.
No sanctions.
But
And
the
they are
ru-
not before the court.
Yeah.
They are not before the
Yes.
trial court. Only the petitioners are before the trial court. So 120B, can it exist?
My submission is that when there is no sanction also, when the role has been played. I may be in a wrong track,
But
my
now,
lord.
how can it be proved now when the other side is not there?
Exactly, yes.
So I left that because I've been submitting that if they face the trial and that ground does not exist against them, they can have a honorable acquittal. That is what I'm just trying to
In
say.
the first place, that charge should not have been framed, 120B. I think you also agree with me inside.
For that,
120B, how could it have been framed when the other side is not there at all? Isn't it? Okay, 420B framed, fine, we'll examine, but 120B should not have been framed at all. Anyway,
Yes. Now, in the celebrated judgment of Topan Das, 1956, All India Reporter, Supreme Court 33, the with regard to 120p, it is a judgment where the students of law are being taught all over the country. And in that, it is clearly mentioned that a lone person cannot be,
That's what I'm saying.
yes, prosecuted for, yes. I have sent one of my
Where is
juniors,
that?
yes, to get the book. I will be placing it or giving it to the court master shortly. The citation is 1956 AIR SC 33.
1956. Anyway, since you're
My lord, my
producing
lord.
the book, yeah.
Now, my learned friend has made a submission beyond the record, beyond the allegations made in the charge sheet, that my signature is present in the
MP book.
MP book. But in paragraphs 16.24 and 16.30, there is no such allegation which speaks about signatures of the government engineers being present in the MP book.
No, my lord, I think that submission he has taken in other sense. My submission, it was only is that in the there should be a MP book must be maintained. In that MP book, in order to maintain transparency, either the contractor or the agents and the officials, they should make entry for every payment or the work executed. That is what I've said. I didn't indicate that it is there in the MP book. That is the wrong indication that he received.
It seems the executive engineer signs the MP book and then it is signed by another engineer. The junior engineer, I think, as per paragraph 16.24, and the executive engineer, he countersigns it. So the signatures of two engineers is present in the paper book, measurement book. Page 99, my lord. You know, for the purpose of clarity.
Where is that? Page 99?
Page
Para?
99, para 16.24.
Oh, yes, yes. It
Yes.
says the prepared by
Yes, my
engineer
lord,
such
and
and such,
countersigned by so and so.
countersigned by the
Yes, all
GE,
these are government engineers.
and passed
not
for
us.
payment.
And in para 16.30 also. They are speaking about expert opinion, handwriting experts. 16.30. Further, CFSL Gauhati has also given positive opinion of the signatures of the accused engineers of NPWD, RNB, namely so and so, so and so, so and so, in the said running account bills and measurement books. Yes, not us, not the contractors.
That's all.
Now, my lord, so far as page 96 is concerned, para 16.20.
96, yes.
Yes. My friend has read para page 96, para 20 Roman 4. 16.20 Roman 4 at page 96.
Roman 4, yes.
Yes. One of the pleas taken by the accused contractor is that though the work order was issued in the month of February 2008, the construction of the road with pre-mixed carpeting had been done before the laying of the foundation stone of the High Court building on 21/5/2007 by Honorable Chief Justice of India in presence of the Chief Minister of Nagaland and other dignitaries. Now this is important. However, some photographs of the said foundation which were seized during investigation of the case clearly shows that there was no premixed carpeting on the ground area of the High Court complex. So that means it shows that, my lord, only after when there was no carpeting and no construction in 2007, when the High Court foundation stone was laid, then it shows that I constructed the work, I executed the work only after work order was issued.
5 minutes. Are you completing now? 5 minutes?
5 minutes I'll be.
5 minutes.
I'll be.
Yes.
On the issue that
This shows what?
it shows that, my lord, that I had executed the work only after the work order was received. It states that, however, some photographs of the said function which were seized during investigation of the case clearly shows that there was no premixed carpeting on the crown area. So they are saying that there is no carpeting, no premixed mixing done. That means the present contractors have executed the work only after the issuance of the work order in 2008, and when the High Court foundation stone was laid in 2007, there was no work done. Now,
why they are saying that is because one of the pleas taken by
Yes.
the contractor was that you had already started the work before the laying of the foundation stone. That's why they are saying
yes,
that.
Yes, my lord, my lord. But what I'm saying is that this statement is wrong.
No, Lord, every
Is that
statement
SCP,
given
my
by
lord?
the CBI investigating agency, if it is supposed to be in his favor, there wouldn't be no case.
Be that as it may, my lord. Statements made before the police, it is not admissible in evidence. On that issue, I may be allowed to place a single judgment 2024 SCC online SC 3803. I will highlight the relevant paragraph, paragraph 10.
Yes, where is that?
Paragraph 10 and 24. My lord. It speaks about statement made before the police being inadmissible in evidence.
No, that is
Yes.
settled now. Yes.
Yes. Now, my lord, again, they have relied on the statement in the same paragraph, which was also read out, Roman 3. This is a man accused in
My Lord, this is not
allegation
a
number 1.
statement. This is a finding given by the investigating agency. It's not a statement. Charge sheet. I think that is the wrong reflection, that the indication that is given to the court. This is not a statement given before the police station by the accused person.
No. What they're trying to say is
Yes.
that the statement that the work or they had started to work before the foundation stone,
Yes.
that was made
Yes,
before the
yes.
police. That's what they're trying to say.
Yes.
But if it reflects to the charge sheet.
No, but
it
these
reflects
things,
like
whether it was made before the police, not made, these things are
These
matter
are
of
not
trial.
immaterial
Yes, my
here.
lord, my lord.
These
We
are
will
immaterial.
not take that into consideration.
My lord.
Yes, anything else? You wrap it up now. And
Yes, my lord.
you also give, like I said earlier, written arguments in the sense, especially with regard to your calculation,
With regard to
the calculation of the amount that the taxes, after taxes, this and that, this
no,
amount.
the
that
amount is, my lord, it is clearly reflected in para 16.28.
I think
Okay,
he has
okay.
read it
So
out,
if
but
we,
it is
if
not.
we deduct the
Anyway, you
plus minus
just
is done,
submit
then
written
yes.
arguments also.
My lord, it's a
That-
matter of simple addition and subtraction.
That's all.
My lord, that's all. And as such, my lord,
Just
I pray that the
stand. Yes.
charges against the present petitioner is groundless, and that they deserve to be discharged from the instant case.
Okay.
My lord, shall I also submit my written arguments? Of course.
Yes.
Then in that case,
Written arguments, maybe not necessary, but then the judgments, list of judgments with paragraphs, with the relevant paragraphs.
The amount, my lord, I will furnish to the court master within 3 minutes.
Same submission in all three.
Yes, same
Yeah,
submission,
yeah.
yes, my lord.
One submission will
allocation.
cover all the.
You write, it'll be just one line. You give it to the steno. Heard learned counsel Sintianger for the petitioners and Mr. Bandangwabang, learned PP for the respondents. Hearing concluded, order reserved.
Deeply obliged, my lord.
Much obliged.
Done, haven't done.
Itu hari lagi lah, kita dulu buat apa sih? Kita nak kita nak itu itu apa namanya itu lah itu अभी तो सुबह सुबह दो अभी तो ऐसे ही है अच्छा ना अमन PDF ko na ilan na? Ito. No, saka na. Many times, such system yun na karigo na. So, kung buwan mo na, also, kasi mga sige suwo, o kasi na ito.
For admission, item 23.
Itu tu pun tu langsung. Oh, itu CV additional. Itu lah langsung. Itu CV ada. Yes.
Yes, Your Lordship. Lordship, the petitioner hearing has filed his present bill application under section 483 of the BNSS, praying for release of the accused person on that. The brief gist is that on brief gist of the case is that on 11/06/2026, an FIR, Sumoto FIR was lodged.
Are you also assisting?
Yes.
Why are you without the band?
On 11/06/2026, the Sumoto FIR was lodged, stating that the present accused that molested a minor, age 17. And thereafter, the accused was arrested and he was booked under section 74-75 BNS and section 8 of the PROCEEDINGS Act. Now, the petitioner filed a bail
When
application
were you arrested?
on 11/06/2026.
11/06.
And thereafter, the petitioner approached the special judge POCSO and filed a bail application number IN number 115 of 2026. However, the same was rejected by order dated 03/07/2026. The same is annexure B, my lord.
Next year?
B, my lord. B. The order of the lower court.
Next year B.
While in judicial custody,
On what grounds?
ground of arrest, my lord. That ground of arrest has not been supplied to the
No,
family.
the rejection?
Rejection stating that the ground of arrest, it was mentioned in the case diary that the ground of arrest was supplied to the family. But in the case diary it was mentioned, so the special judge also rejected the bail application.
The case diary reveals that the accused was apprehended from his presence produced before the case was found the project and before the still underway to report the statement of the victims. Okay. Yes.
Now, my lord, while the accused was in judicial custody in jail, the IO prayed for remand again for 3 days. And the court void order dated 01/07/2026 allowed the remand again. After the accused was in custody, now it is allowed under BNSS.
Okay, that is permissible.
Yes, that is permissible. However, my lord, the accused was never produced before the court, physically or through VC, and the remand was allowed. This is gross violation of section 187(4) of the BNSS, my lord. On this ground also I am taking my lord. And this is not the first time. Then again, void order dated 10/7 after I filed this application. Then the IO again sought 5 days. In that order also, the accused was never produced before the magistrate. Directly from jail to the police station. He was never produced.